And I think the Lord specifically referred to paragraph 53, but if I can invite the court to remind themselves of what was said in paragraphs 51 and 52 as well there. I'm sure Lord Justice Snowden doesn't need to do that. But
where are we starting? 51?
Paragraph 51, page 213, tab 8.
If I may, could I ask the court also to look at 49 and...
Yeah, certainly.
49?
49.
Right.
So,
Yes.
so the language that we see in paragraph 52 about ascertainability and so on, and repeated in 53, is the language that we've seen has gone into recital 30. I said before the break that I'm not aware of the source in the ECJ judgments of the language that went into recital 28. Mm-hmm. That's not to say that it doesn't come from an EC judgment. I'm just not aware of it. But that regulation, that recital rather, says what it says, and this case is a pre 2015 judgment. And in my submission, the ECJ here isn't ruling anything in or out specifically. It's saying one thing may not be enough, unless, and sorry, this is paragraph 53. The things mentioned there may not be sufficient unless a comprehensive assessment under the regulation as then existed led the court to an actual conclusion one way or another. I'm not sure, and in our submission, it's not saying any more than that. And of course, at the risk of repeating myself, in most cases there will be a comprehensive assessment because there will be a company giving the court something to go on. Here, we're on our case, we're faced with with the opposite situation. So I don't know whether Lord Justice Snowden wants to discuss this with me.
Is there anything in the Advocate General's opinion which might help, which is not printed in this report?
My Lord, I confess if there is, then I'm not in a position to draw it to the court's attention.
I mean, it is generally understood that, and I think I do have the Travo, if necessary, but not here, that interradial and the text of interradial was used by the EU to form the basis of the recitals. I mean, there's no doubt about that.
No, well, it's quite plain that this language has got pretty much verbatim, has gone into recital 30.
Yeah.
My only query was in relation to recital 28. I'm not, because we don't find an equivalent form of words for that, I don't think, in inter idle.
I mean, in paragraph 49, at the end of paragraph 49, Mr. Sheehan asked us to look at as well. I mean, what the ECJ there appears to say at the end is, first of all, to say either the factors have to have been made public or at very least sufficiently accessible to enable third parties, that is to say in particular the company's creditors, to be aware of them. So I imagine you would say that again emphasises the creditors historically rather than some hypothetical person.
Well, how can you have third parties, why say third parties and creditors?
Well, third parties, that is to say in particular, yes, again, in particular the company's creditors,
It would just be third parties.
My question about 53 was linked to the fact pattern that I put before you, just before lunch, which was...
That's where I batted off the point of my favour.
Well, the danger when I ask questions, people assume it's the
fairest intent.
But there is, I think you say, a logical problem with hypothesising a particular typical person who may not be one of, well, first of all, it's difficult to do if you've got two different creditor groups, which are separate and distinct, whose experience of dealing with the company may be different. The test is a very difficult one to apply in that circumstance, whereas if you actually look at the experience of the real creditors, but putting aside for this purpose the particularly gumshoe orientated investigatory creditor who may have his own particular access to information, then you get a better fit.
So, my Lord, that's what we say about inter edel. My Lord, a few words about the operational and administrative debate. We say that every situation has to be looked at on its own facts, and that's plainly true. The factors that and one man's operations may be another man's administration, but the factors that the deputy judge found, for better or for worse, but we say nonetheless were open to him to find, were administratives where the company was administering its assets. A shows in action is an asset. And the judge found, A, that those were being done, or rather, in the UK.
Wasn't it trying to avoid liability?
Sorry?
The company wasn't pursuing an asset. Wasn't the company the respondent?
Well, so my Lord's obviously right. In the first place, we've got the charter party, and then we've got the arbitrations,
in which you sued them.
in which we sued them. Yes, as well, but that's where the company is administering its affairs. Those are the affairs of the company. It may not be an interest in the sense, sorry, you're quite right, it may not be an interest in the sense of a shows in action. But it would turn into a debt. And that's where, and the suggestion that interests cannot mean liabilities or assets.
Right, it's trying to avoid a liability, which would, in the ordinary state of things, dilute the availability of assets or avoid insolvency.
So we say that the deputy judge was right in that, and that Mr. Justice Miles was wrong in paragraphs 71 and 72. In the interest of time, I'm going to try not to go there to give Mr. Sheehan a fair chance at things, but do have a read of that, of what we say about that in our written submissions. My Lords, the weight of the presumption, we suggest that there is nothing on the face of the authorities to suggest that this is a particularly weighty assumption. There are lots of, presumption, not assumption. There are lots of presumptions in law. There's a presumption of advancement, which can be batted off quite easily. I think it was even going to be abolished, but Parliament never got round to passing the relevant act, I think. So there's that presumption. There's a presumption of innocence, which obviously takes proof of guilt beyond reasonable doubt. All sorts of presumptions all over the place in the law. There is nothing on the face, so far as we are aware, of the authorities to suggest that this should be a particularly difficult presumption to rebut. There are a couple of early decisions of His Honour Judge Langham, QC, one of which, I think the second of which, we refer to these in our written submissions, the second of which re CI 4net, I think my Lord Justice Lewison said was wrong in Stamford at first instance.
Yes, because I think,
And it must follow.
I thought the judge in CI 4net just treated the location of the registered office just a factor to take into account,
Yeah,
rather than starting with a presumption.
yeah. And we accept that it probably follows that if His Honour Judge Langham was wrong in CI 4net, that he was wrong in the one, the case that preceded it, where I think he reached the same conclusion. But there's nothing to suggest that this is a particularly weighty presumption.
Yeah. No, it's paragraph 20 of Judge Langham's judgment, where he says that no reason to suppose a presumption is particularly strong. It is rather just one of the factors to be taken into account. So that's what he says.
Yeah.
And that's what I said was wrong.
Yeah. It is a real presumption, but where that concession takes anyone, which is a real presumption, isn't altogether.
Well, it puts the burden on the person who wants to displace it to introduce evidence of sufficient weight to displace it.
Yeah, but it's probably a burden of proof. It probably comes down to a kind of burden of proof argument.
So if you don't have sufficiently weighty evidence pointing
Another way.
to one other jurisdiction, not a variety, you are forced back onto the presumption.
Yeah. Yeah.
So was it right for the deputy judge to say, well, it may be UK, maybe Switzerland, not sure, that's a close call, I'll plump for one or the other, rather than saying, well, actually neither of them is sufficiently weighty.
Well,
I can't be clear that either of them is actually the centre of main interest,
well,
therefore we're back to the presumption which at least has the benefit of certainty.
yes, we say it was open to him to do that, because one thing is a presumption, i.e. Malta, but that doesn't presume, the presumption is only a starting point or a useful end point if you can't get anywhere else. It doesn't actually, when one's relying on the presumption, one's not looking at the same things as one is looking for Comey. One doesn't have to look for anything for a presumption. All you've got to do is look for one piece of paper at a register, on a register somewhere. And so if the court is entertaining a debate about Comey, it is perfectly open to the judge in a difficult case with a party that doesn't disclose what it said it would and what the court might expect it to disclose. When given tidbits, maybe, not the strongest stuff in the world ever, but when given some tidbits, to say that's where the Comey is. And if the company wants to say it wasn't that, then it can, then it should have done what it said it would, and come along with some evidence in the other direction.
Yeah.
So that's what we say about the presumption. Lennox, I think I've already touched upon whether the deputy judge went wrong by reference to Lennox. We say he didn't, and that it's unfortunate that he was referred to Lennox and that it was included in there. But when one actually follows the deputy judge's analysis and reads his judgment, it's quite clear what he's actually doing, and he's not falling into the Lennox trap. Going back, penultimately, if I can just deal with the Leon Mobile case, probably I should have dealt with it when dealing with the presumption, and rebutting the presumption. I mean, the case is obviously somewhat different to ours because that was a bust up on it between inter-European commies. Ours isn't, but given that it deals with the presumption and the rebuttal of the presumption, it's only proper that we do consider it.
Sorry, why is that so different?
Sorry?
Sorry, I don't get the point you just made. Why do you say it's so different?
Well, our case is not a straight EU argument.
No, I understand that, but you were trying to establish jurisdiction in an EU member, what was at the time an EU member state.
Absolutely, and dealing with it, and that's why we say we have to have regard to Leon Mobile, because it deals with the presumption and how the presumption is rebutted. No more than that is.
Right, and Malta?
And Malta.
Yeah, I'm trying to remember what my EU member states are. But
no, Malta was an EU member.
Yeah, so
no, we say that. Sorry, I think we're in violent agreement. We say Leon Mobile is relevant because it deals with the presumption.
Sorry, I thought you were trying to draw a distinction when you introduced it. Sorry, okay, if you weren't, that's fine.
As it relates, we say that Leon Mobile was a fairly orthodox application of Eurofood, a case that it cited, and we saw that earlier. The next point we would say, and this is apparent from paragraphs 37 to 39, which I think we looked at this morning. The fact that the company has a registered office in one place and nothing anywhere else can be relevant. But importantly, that a fictitious transfer is something that the court should take into account, but only as part of the overall assessment. We keep coming back to this concept of everything goes into the pot as a part of the overall assessment.
And by fictitious, you mean a transfer of registered office for no business reason?
For no commercial. Well, the language, I think, I say fictitious because that's a language.
Well, it can't be fictitious because it happened.
But yes, but that's the language of the translator or whatever else. I also think it's actually the language that I understood from the original French, but that may be my fault. But certainly, certainly a transfer of registered office for no commercial reason, and not because there was any commercial activity going on in the jurisdiction of the state to which the registered office has been transferred. And the final point in relation to Leon Mobile is, we say conceptually, it does indicate that the registered office presumption can be rebutted with relative ease.
Can be rebutted?
With relative ease. There is no doubt that the registered office was in Bulgaria. Nothing in particular had changed about the company. And insofar as we understand the toings and froings between the various courts in Lyon, Mobile, despite the fact that the registered office had undoubtedly changed, I think the originating court in Bari and the ECJ said, no, it's not the Bulgarian court, it's the Italian or the Bari courts. So that's what we say about that. The fundamental, the overarching point on which we close is this, that none of my lords may have reached the same conclusion on the materials that were before the deputy judge, or in the circumstances that were the deputy judge, the unfortunate circumstances that the deputy judge was presented with. But it's only if that the court thinks that no judge could properly, or if he didn't err in law, that no judge could have had regard to those factors and reached the conclusion that he did.
Well, I'm not sure I'd quite phrase it like that. As I've said to you before, first question is, was Mr. Justice Miles entitled to interfere with the Deputy Judge's decision? And he would be entitled to do that if he considered, and we consider, if he considered and we consider that the Deputy Judge's decision was wrong, as that expression is used in the CPR. So it will be wrong if he made a legal error. It will be wrong if the multifactorial evaluation which he carried out was one which was outside the bounds of reasonable disagreement, and for all the other reasons that an appeal court is entitled to upset the decision of a lower court. If we reach the conclusion that Mr. Justice Miles was not entitled to interfere with the Deputy Judge's decision, your appeal succeeds, without regard to what how Mr. Justice Miles reasoned. If, on the other hand, Mr. Justice Miles was entitled to interfere with the Deputy Judge's decision, the next question for us is whether Mr. Justice Miles was wrong. And for the most part, you say he was, because he adopted the typical third-party ascertainability test, by which you say he meant a hypothetical creditor, and did not pay regard to what your clients had in fact, what they perceived. If we are with you on that, with a consequence that Mr. Justice Miles was wrong, then we will remake the decision.
Yes.
That's the flowchart, so to speak.
Yes. I'm grateful for that being done for me, but that's certainly where I intended to get to. But on any analysis, we say that our appeal shall succeed. My Lords, I've gone on too long, but it's certainly before 2:30. I apologise to my Lords and to Mr. Sheehan if I've eaten into too much of his time.
All right. Thank you very much, Mr. Levy.
Right,
right, Mr. Sheehan, I'm sorry you've got to get your skates on.
I understand that, my lord, and I will do everything that I can. I'm grateful to my own friend for going over some of the authorities. I hope that I'll need to spend a little bit less time on that, although I need to make some points of my own in the usual way. Dealing then first with the law, my lords. The first point that I want to make is about the importance of ascertainability. It is clear from both my Lord Justice Lewison's decision and the Court of Appeal's decision in the Stanford case that the court is concerned with what is either in the public domain or what would be available to typical third parties from dealing with the company. There's a very good reason for that, and a good reason in particularly for limiting the scope of the inquiry to those factors, and that is the need for legal certainty and foreseeability, which underpins really the whole of the regulation on this point, and the whole of the case law which applies it. The risk of trying my Lord Justice Lewison's patience, I would like to go briefly to the first instance judgment in Stanford, so that we can see what the genesis is of that typical third-party test. It's tab 5 of the authorities. You can pick it up probably at page 84. That's where my Lord starts the analysis in relation to Comey. And of course, this being a uncitral case, the Lordship started by explaining the interaction between the two tests. Over the page in paragraph 47, there's a reference to the Virgos-Schmidt report, which is actually, as your Lordships will know, the report for the proposed convention on insolvency procedures, which wasn't brought into force because the UK refused to sign it, but is generally treated as relevant to the interpretation of the 2000 regulation and, moreover, the 2015 regulation. And paragraph 75 is quoted at paragraph 47 of your Lordship's judgment. The final sentence, sorry, the final two sentences, insolvency is a foreseeable risk. It is therefore important that international jurisdiction, which, as we'll see, entails the application of the insolvency laws of that contracting state, and I'll come back to that, be based on a place known to the debtor's potential creditors to enable legal risks to be calculated. Pausing there, there's already then, from the very beginning, emphasis on the potential creditors. This is not something which has somehow come out of the 2015 regulation. And that's important to my learned friend's submission, that when we get to the 2015 regulation, recital 28 somehow changes everything and allows this court to disregard or take a different approach to the test which has been promulgated in the existing authorities. That is not the case, because it always has been relevant, and the test, as I will show you, Lordships, is...
I think what I got from that, rightly or wrongly, was because it all has to be foreseeable and the legal risks have to be calculable, it's based on what you learn in your dealings with the company rather than what you might learn if things go badly wrong and you want to wind them up.
Quite, my Lord, and I respectfully would agree with that, and it's, as we'll come on to see, is one of the fallacies in my learned friend's submissions, that actually where he is wrong, where the Deputy Judge went wrong, is that many factors were relied on in the assessment at first instance, which did not meet that test, because they were not factors which would have been available to typical third parties. In fact, they were not factors which were available to the petitioning creditor in this case. But the importance of the time of the investment is clear.
Yeah, but wait a minute. You look at what's known to the creditors before they become actual creditors. In other words, when they're dealing with the company, because they make an assessment as to whether to deal on the basis of, amongst other things, insolvency risk.
Yeah.
And having decided to deal on the basis of an insolvency risk, it would be contrary to commercial certainty and throw cat amongst pigeons if you suddenly decided to apply a different test. So, or if the Comey didn't turn out to be at least where they had envisaged it might be. But then they become real creditors. And in the course of being real creditors, they may also continue to deal with the company. Indeed, may deal with the company after the company encounters financial difficulties. And at that stage, you will also take into account what they know about the company in the course of dealing as actual creditors. And the company may move its Comey for restructuring reasons, for example. There are cases where that's happened. Indeed. And you take their interests or you take them into account at that stage. So these are real, although it says to the debtors potential creditors in that paragraph, they will become the company's real creditors if they deal, because otherwise, there's nothing.
Indeed, my Lord, I don't dissent from any of that, with respect. What one sees in the scheme of it is that the starting point is, well, what would the actual creditors or the potential creditors at time of transacting have perceived? that is important because they would be calculated in
Yes,
solvency.
but it's not
risk
the
at
end
that
of the
stage.
inquiry.
It's not the end of the inquiry.
Right.
One obviously would then go on to see what they would have perceived over time in the course of their dealings with the company. As we all know, the registered office and indeed the COMI is not an immutable concept. And as Justice Snowden pointed out, it's quite frequent, not just in the case of German individuals who want to be discharged from bankruptcy after a year, but also quite legitimately companies that want to take advantage of the scheme of arrangement jurisdiction in this country and so on. Yeah. But the question at that stage will be, quite frequently those companies might say that their COMI is in England but without moving their registered office here. Then one will have to look at whether the factors support that conclusion. Yeah. In other cases, there'll be actually a move of the registered office, which will then bring with it the benefit of the presumption. And then the case will be looked at the other way around. Are there in fact factors which displace it? But what is not relevant, in my respectful submission, it is matters which have been taken into account by a creditor, either in the course of proceedings on a winding up petition, which is what's happened here, or even having finished their dealings with the company, if you like, and deciding that they want to wind it up, then conducting investigations to find out where it might be in their interests to seek to wind up the company. The question is fundamentally always dealings with the company. I think we can probably then go forward in this decision to page 89. And there's a passage which is important generally, but maybe not so important in this case. Paragraph 61, where His Lordship is looking at whether a head office functions test is the right test in the absence of ascertainability. Answer no, and that's very clear. Head office functions may be relevant, but only if they are ascertainable. And then there's a Lordship quotes towards the bottom of that page from the Court of Appeals decision in Shearson and Vlieden Body, Lord Justice Chadwick. In that inset passage, again, a reference to the importance of creditors and potential creditors. Again, that is not a new concept. And then, I don't think I need to dwell on this, but as Justice Lewison pointed out earlier, the submission that was put is that a factor is relevant if it is something which a creditor would ascertain if it asked a question of the company and got an honest answer. That is not the test. We're not talking about probing the company. One's simply talking about what would, in the ordinary course of business, the creditor or potential creditor learn from its dealings with the company. Over the page, just to deal with the point my learned friend made towards the end of his submissions about the weight or importance of the presumption, which I will come back to. Paragraph 63, Lord Justice Lewison's assessment of the Eurofood case is that the European Court had emphasised the importance of the presumption. I respectfully agree with that, and in fact it's plain from all of the cases in my submission that the presumption is an important one. It's not correct to say that it's weak or not especially strong. And the CI4net, Judge Langan's decision in CI4net was expressly disapproved. That's, I think, all I need to go to in that decision. If one's looking at not what one would ascertain by asking questions, but what one typically might learn about a company from doing business with it, there are many things that might be indicative of COMI in an ordinary case. One might find the office address of a company on its correspondence. What one might see, and in fact one did see in this case, bank details being communicated.
Well, I think at 98, on page 99, I set out the various factors that I was being asked to take into account, and I evaluated them.
Yes, indeed, my lord. I was talking really as a matter of generality, what one find in any case, and when I agree in relation to these slightly different facts from these, of course, in Stanford, because on the one hand there were many real, actual factors on the ground, if you like, that pointed to one place, and on the other hand it was being said, well, actually, this was all a fraud, and the fraud was being conducted from elsewhere, and so the point obviously turned on whether the fraud-related factors were relevant. But just as a matter of generality, other things that one might find would be contact details of senior employees on correspondence or on a website, where one's invited to meet with the company's representatives, where it's registered for things like VAT or with a company's house or some other equivalent, who it's regulated by, and so on. And in relation to terms of business and contracts and so on, one can see, assuming against my submissions, that contracts and in particular jurisdiction clauses may in some way be relevant. It is possible, I accept, in some cases to see why they might be. I postulate this example. A company is incorporated in France, but there are some suggestions that it has people, senior representatives and an office in Italy. And there's a question of whether actually its COMI is really in France or really in Italy. And the company deals on standard terms of business, and it refuses to deal on any other terms. And when one looks at those standard terms of business, one sees that they require counterparties to sue and be sued in Italy. In that sort of case, one might then go on to say, well, why is that? Why is the company choosing to sue and be sued in Italy and in fact requiring its counterparties to agree to that? And the answer might be, it might not be, but it might be, that is indicative of the company's preference to litigate disputes where its centre of main interest is. It may be in that sort of case indicative. What it's certainly not indicative of is where you have a charter party for the transport of oil in the Caspian Sea, which is on standard terms, and there's an English arbitration clause. One can't get from that a respectful submission with any degree of reality at all, and that is an indicator that the company is administering its interests in England. And I said at the outset, ascertainability is important for certainty and foreseeability. The reasons for that are obvious. The governing law of the insolvency is dictated by the COMI, which will govern all kinds of things, from which insolvency regimes exist in the first place, how assets are distributed, how security interests...
It's all to do with insolvency risk.
Indeed.
You need to know what the system's going to be and where your debt is going to rank in the general distribution of assets.
Well, exactly, which could determine whether a creditor insists on security of a particular type and so on. I mean, these are all things that are relevant at the time of dealing, which is why it's important to look at that time as a starting point. They might also be relevant later. If there's a move of the registered office, then that is a public factor that creditors can look at, and they can then see what the consequences of that might be after they've had their agreement with the creditor. For example, if I get paid in these circumstances, will it be avoidable preference, that sort of thing. So the cases make clear in my submission that ascertainability is a core factor, and they also make clear that one is looking at an objective test. That's the language that's used in the Interredo case, objectively ascertainable. That's why...
I thought it was ascertainable by objective factors. Is objectively ascertainable, is it? That's the phrase?
I may have misspoken. Could I come back to that, because I'm going to look at the
criteria that's
both objective and ascertainable.
Yeah, that's right. I'm grateful. So the criteria which are relevant to the assessment have to be objective factors.
Yeah. I mean, it just means, well, I mean, on one view, it's just simply saying you can't have a whole host of creditors saying, we thought the Comey was in a certain place, and the court saying, oh, okay then.
No, indeed. But it's saying slightly more than that in my submission, because there are sort of two distinctions in one sense. There's a distinction between, on the one hand, what somebody asserts to be the position, which clearly is not the test, because one has to look at objective factors. But it also means, in my submission, that a creditor's subjective experience, however real it may be, is not the determining factor unless one can actually conclude from that creditor's subjective experience that the Comey is in a particular place.
Well, I think you're using subjective in a strange way there. I mean, I don't think you mean by subjective the creditor, how was it for you?
Well, that's why I refer to the two senses.
But it's an objective factor that a creditor entered into a contract with the company. I mean, it's part of their experience, but it's an objective factor, if it were relevant.
Yes, and it is important to make the distinction between the two, my lord. The point I'm making is that it's neither the creditor saying, well, this is how it was for me, but nor is it.
No, but it would be an objective factor to say, well, we entered into a charter party, which was in fact signed in London. Yep. It in fact included a London arbitration clause. We paid our hire by transfer into a London bank in sterling, whatever. Those would all be facts.
Indeed. And the point I'm making, and perhaps I'm making very well, but I'll come on to the facts, I think will perhaps make it a little clearer, is that if you have creditor A and creditor B, and creditor A says, well, look, the objective facts about my transaction are, as my lord has put, creditor B comes along and says, well, the objective facts about my transaction are totally different. Everything's focused on Italy or Belgium. Then the court is not absolved of its duty to conduct an overall assessment of all of the objective factors in order to reach a single conclusion. And that's really the point that I'm making about subjectivity in that regard. That it may be a starting point, but it certainly isn't the end point for a particular creditor to come along and say, well, my experience was as follows. And the overall assessment has to be of all of the factors.
But in those circumstances, it might be for the company to say, yes, but you're only one of 100, and everybody else we dealt with, we contracted by contracts entered into in the BVI and BVI law with arbitration provisions in the BVI, etc. You were the outlier. So when we take into account all the objective factors, it would be apparent that, in fact, the centre of main interests of this company are in its 99 BVI-oriented contracts rather than your one English law-oriented contract, and only the company would know that, and the company would therefore be able to bring forward the evidence to counter what would otherwise be the creditors' individual experience.
And a lot's been said at the various different levels of this case by way of criticism of my client for the evidence or lack thereof that was put forward. Fundamentally, my client's position has been throughout that its centre of main interests, as of the move to Malta, is in Malta, because that's the operation of the presumptions, of course, open to my client to do that. It hasn't come to court and said.
Well, so you say that that's its position. You're just stating a submission there. I don't think you're stating any evidence that was to that effect.
No, indeed, but in terms of the evidence, it's quite right that we haven't come forward and said, and look, here's our building where we employ 1,000 employees in Malta. There is no building with 1,000 employees in Malta. Nor have we come forward and said we've got 50, 99 other transactions which all point to the BVI. But what we have said, and what is on the evidence, and I'll come to it, is, okay, you, EWL, the petitioning creditor, had a contract, governed by English law with arbitration in London. There were other counterparties. There's a company called Dartex, which had a contract with a Geneva arbitration clause. It was also on the evidence that Melars was sued in the BVI by EWL, it's also on the evidence that from 2012 onwards, right up to and including and after the time of the petition, Melars was pursuing proceedings in Switzerland, debt collection proceedings and also criminal proceedings, which have now resulted in a judgment in Melars' favour against Mr. Pesov. And on the basis of all that evidence, when one carries out the comprehensive assessment which is mandated by the authorities, EWL is unable to show that its experience can be extrapolated, one way of putting it, can't show that its experience is typical. EWL can only get to the starting point where it comes to court and says, look, here's my bucket of factors that I've relied on in support of England. When there are a number of other factors, whatever one might say about how forthcoming or not the company has been, there were plenty of other factors in the evidence which pointed away from England. And in those circumstances, it doesn't work, with respect to my learned friend, to say, well, look, the recital 28 is the beginning and end of this case, because one needs to look at the perception of actual or potential creditors, and that somehow means that EWL's own position can rule the day. The suggestion my learned friend made, which he relied very heavily on, was I think that one doesn't have to look at the old cases, or there's somehow less weight, or I'm not entirely sure what he made of it, but he was certainly saying that there is I think he described it as a sort of trump card, to rely on recital 28. The reality is that the need for factors ascertainable to third parties in a general sense, objective factors, was there right at the beginning and still is there now. And equally, the importance of creditors was there at the very beginning and is there now. All of the old cases remain just as relevant now as they were under the 2000 regulation. And if there were any doubt about that at all, my lords, there is a case which I dug out over the short adjournment, which is a decision of the Court of Justice in 2020, which makes this precise point, and I may just refer to it briefly if I can.
Can I just
also
observe that there's no criticism.
Wanted to hand up earlier.
No, we got ours after we came back to court after the short adjournment. I did have a copy on my mobile telephone.
So you haven't read it?
Sorry?
So you haven't read it?
Couldn't see it in the... No.
Right. Well, how do you want to deal with this, Mr. Sheehan, if Mr. Levy hasn't had a chance to read it yet?
Well, my lord, I hear what my learned friend says about it. It's become relevant because my learned friend, for the first time this morning, made a submission based on recital 28, which hadn't featured at all in his skeleton. And indeed, most of his submissions were based on that, as far as the law is concerned. And so it's been prompted by that submission that I've identified this case over lunch. There isn't very much to it.
Well,
in fact,
make
but
your
I would propose to
submission,
make my
and
submission.
if Mr. Levy needs time to consider it and reply, we can let him do that in writing.
Very well. Well, the case was a case in relation to individual insolvency, and it concerned factors which in part were specific to individual insolvency, and so the facts I don't think we should dwell on particularly, but what is important is the treatment of recital 28 and the need for objective criteria. And the same points are made in the Advocate General's opinion, but could we pick it up, please, in the judgment at paragraph 16 on page 2517. The simplest thing actually was maybe to ask the court to read from paragraph 16 over the page to the end of 23.
Where are we reading to? End of para 23?
23, my lord, please.
Yeah. Yeah. Yes.
So, my lord, the short point is, Cycle 28 is a helpful clarification as far as the legislation is concerned, but it reflects the old case law, and the remains essential is to carry out a comprehensive assessment of all of the objective criteria. If the balance had shifted in the way I understood my learned friend to suggest, one would expect to see some authority to support that, either in the cases or in the textbooks, and there is nothing which begins to support that submission. My lords, on the strength and weight of the presumption, this really is quite a straightforward point in my submission. There's a presumption that the commis is in the place of the registered office. That applies, as Article 3.1 expressly provides, in the absence of proof to the contrary. In order to prove the contrary, somebody, might be the petitioning creditor or it might be the company, needs to identify a single rival candidate which displaces the presumption. And it needs to do so applying the tests which Lordships will be very familiar with, that my learned friend looked at in the cases and in the recitals particularly, but also in Article 3 of the regulation itself. It's been common ground throughout these proceedings, and is not challenged today, that the standard of proof, in this jurisdiction at least, is the balance of probabilities. So one's simply looking at whether, in this kind of case, the petitioner has discharged that burden of proof to the necessary standard. And my primary point is not particularly helpful with respect to go beyond that and say the presumption has a particular weight in a particular set of circumstances, because it all depends on the facts. And that's what Mr. Justice Miles expressly recognised. He expressly recognised, for example, that the fact that the company had moved to avoid winding up, as the deputy judge had considered, was plainly a relevant factor. But ultimately, the question remained, applying the test, whether the presumption had been displaced. One can see that, if we could just look briefly at it, in the core bundle, tab 5, page 55. This is just after a submission that the judge recorded that the company had moved its registered office to delay winding up. And at paragraph 79, the judge said that's plainly relevant to the strength of the presumption and the ease with which it might be possible to countervailing evidence to rebut it. But I still need to apply the test. And that is what he did in a way which we submit is entirely unobjectionable, but which the deputy judge regrettably failed to do. The suggestion that the presumption is not very strong or is weak would undermine the key principles of certainty and foreseeability. The registered office is a universal, ascertainable, objective factor or criterion. To rebut it, one needs to identify a factual situation which is similarly ascertainable by reference to objective criteria. If it were said to be weak or rather easily displaced, then clearly that would reduce the certainty that the presumption provides and would cut against the whole ethos of the regulation in my submission. One sees actually that reflected in the ECJA decisions, and as Lord Justice Lewison concluded in the Stanford case, in Eurofood, the court had emphasised the importance of the presumption. And one also sees in Teredil, for example, the factors relied on there, the presence of a lease agreement and a bank account, they might be relevant, but they are not enough unless a comprehensive assessment points to that conclusion. And so what the court is saying is that's not enough on its own. It's an important presumption, and it needs to be, can only be displaced if the burden is met. Similarly, the Leon Mobile case, quite striking in one sense, because that is a case in which the debtor had moved its registered office 2 months before the first request to open insolvency proceedings. And the court said, well, yes, that might be relevant, which it clearly might. That's just a matter of common sense. But, and then the court went on to repeat the same test, which is correctly articulated by the Court of Appeal in Stanford about typical third parties, and was correctly articulated and applied by Mr. Justice Miles in this case. My learned friend said that the European Court and the Bari Court went on to find the presumption had been displaced. He may or may not be right about what the Bari Court said, but there's no material, I think, to support that submission before the court. But the European Court certainly didn't do that. The European Court, as it always does, just articulated the principles and said that one has to apply a test. What one also sees in the textbooks, although I don't have time to go through this in detail, that the Eurofood and Interredal cases are consistently treated as reaffirming the strength of the presumption. So I'm going to just give you some references. The Dicey Authorities Bundle, tab 11, page 288, describes the greater weight placed on the presumption by those cases. Fletcher Authorities Bundle, tab 12, page 304, refers to the task of displacing the presumption as an exacting one. That's tab 12, your page 304. I apologise, I'm rushing through these. I don't think it's the best use of time to take your lordships to a series of textbook extracts in any detail, but the references are there. Yeah. Macpherson, tab 13, page 309, for example, referring to the presumption not being easily rebutted.
That's not the most up-to-date edition of Macpherson. Is there anything in?
I don't think that there is. Well, sorry, there is also. Well, it is the same point at 317 in the most up-to-date position. Edition, rather.
You've copied bits of the 4th and the 5th editions. Is that?
I think what's happened here, my lord, is this is actually a textbook cited by my learned friends, and at the time that they submitted their skeleton, the 4th edition was the current edition. Yeah. And so they've also included the 5th edition, which appeared in the interim. But this point is the same. The same text appears, I think, on pages 309 and 317. And then finally, Sheldon, which is the only one of these cases to predate only one of the textbooks to predate the 2015 regulation, which refers on page 322, tab 14, to the presumption being an important one more than a mere factor to be considered.
Yeah.
Could I, at this point, pick up on observations that my Lords were making this morning, particularly my Lord Justice Lewison, about the relevance of the BVI and what was going on in the BVI. Now, our position is, perhaps not surprisingly, the move to Malta had the effect of moving the registered office to Malta, obviously, and bringing with it the COMI, presumptively. By the same token, the straight answer to the question, where was the company's COMI before that, is its COMI was in the BVI, again, by operation of the presumption, without any need to examine any further factors. Well, my learned friend came close to accepting that, I think, but was careful not quite to accept it, but he didn't offer any alternative. And that is quite telling, because really the thrust of my learned friend's case ought to be that prior to 2015, December 2015, COMI was in England. If it wasn't in England then, certainly it didn't move to England as a result of the move of the registered office to Malta. And it is quite telling in my submission that my friend did not actually advance any
Yeah, well, it struck me that if he wanted to rely on entry into a charter party at a time when the registered office was in the BVI, he would have to say that it never was. It was always in England.
Indeed. Indeed, my lord. And that is one of the logical fallacies in my learned friend's position. The proximity of the move to the insolvency is not really something which he developed orally, but certainly something that he relied on in writing. And clearly, as Mr. Justice Miles recognised, and as the court in its reasoned order in the Leon Mobili case recognised, that is a relevant factor. Mm. But it's one thing for a creditor to say, you moved your registered office, but you did so close to insolvency, in circumstances where even if the 3-month rule doesn't operate, the bright line rule, because you were forum shopping, one can disregard that move or treat it as fictitious in some way. And therefore, the court should treat the Comey as remaining in the state of origin, which was the fact pattern in Leon Mobili and one would normally expect to see. That is one scenario that one can postulate, and one can see the logic of, if that were my own friend's submission. I don't accept that would be, obviously I don't accept that would apply in this case, because we say that actually it's moved to Malta and it's something to displace the presumption that it's in Malta. But in most cases one would expect to be able to do that, because one will be able to point to a real presence in the state of origin. That is not my learned friend's position. Essentially what he is saying is that the fact that the company moved from the BVI to Malta 8 months before the presentation of the petition should make it easier for me, the petitioning creditor, to show that the Comey was in England and Wales. And that with the greatest respect to my learned friend, is a total non sequitur. It just simply does not follow at all. And so for all the reliance on forum shopping and the proximity of the move and so on, it doesn't actually assist my learned friend at
Well, that's
all.
partly why I have a difficulty with Judge Baister's approach, because he said, well, nobody's saying that Comey is now in the BVI, therefore I can forget the BVI. Well, it was a historical fact that the registered office was in BVI. And in order to go back over all the things that he went back over, he would have to have satisfied himself that the Comey never was in the BVI.
Indeed, my lord, yes. But it's right to say that we were not positively saying that the Comey was in the BVI at the relevant time, and neither was my learned friend. And so it could be said that there's some artificiality in the suggestion that the judge of his own motion the deputy judge should of his own motion have worked out whether in fact it was the BVI, but he was nevertheless required to do that.
It's not artificial. I mean, he has to, because he doesn't have jurisdiction otherwise.
Indeed, but fundamentally, and this is where it really matters, the question for the deputy judge and for Mr. Justice Miles, and indeed for this court, is and was, has the presumption been rebutted? And so if the deputy judge had properly looked at the factors and considered where the Comey was previously, then whether that had led him to a conclusion that the Comey was the BVI or still was the BVI or not, it would have led him to the conclusion that the presumption had not been rebutted, i.e. the presumption in favour of Malta at the relevant time.
That highlights a point you made a little earlier in your submissions. I just wanted to test you on for a second. You said that the way this works is you start with a presumption, where's the registered office? And it's only if somebody can adduce sufficient evidence to persuade the court that the Comey is in another singular jurisdiction that the presumption is rebutted.
Yeah.
I think, is this right, that you're saying that if the evidence suggests that the company does nothing in the registered office, so the place of the registered office, but conducts all its business from, say, 2 offices, one in the UK and one in the US, and that's where it deals with thousands and thousands, has a substantial presence, Are you saying that in those circumstances, because the court couldn't say that one or other of the US or the UK was the centre of main interests, or was the main centre of interests, that you're thrown back to the presumption that it's the registered office? And if that's right, I'm not saying it isn't, but if that is right, what's the logic behind that, the policy behind that approach?
I do say it's right, my lord, and the logic behind it is that is, in one sense, the whole point of the presumption, that it's the starting point that everybody can see, whether it's the position from the beginning, because the company was incorporated in Malta, is always there, or because it moved at some later date. And
well, I think basically what you say is that from Mr. Levy's perspective, one group of customers perceive the Comey as being in the US, and the other group perceive it as being in the UK, and the only way to resolve the deadlock is by reference to the presumption.
Yes.
Otherwise, you'd have half the creditors starting insolvency proceedings in one jurisdiction and the other half in another one.
Yes, my lord, I would say that. I'm hesitating because, again, I think it depends on the facts. In that, to take my Lord Justice Snowden's example, if you had a company registered office in Malta, and then there was an even balance, but clearly a stronger presence in reality in both the US and UK, but it was impossible to choose between them, then I would say in that scenario it's necessary to fall back on the registered office presumption.
I mean, it's not an unreal scenario. I mean, it is in fact BCCI, I think, although it wasn't the US and London, it was London and somewhere in the Middle East, I think. But we're with the registered office in Luxembourg.
Yes.
But you say that's where the registered office actually has some real meaning, because at least it stops creditors having to conduct detailed investigations as to how them and all their like-positioned people are dealing with the company, and it allows one single place of insolvency and one governing law of insolvency, which may not suit everybody, but at least is a common one.
There can only be one place. There can only be one Comey, centre of main interests. And so precisely in the situation where it's very difficult to weigh the two up, the whole purpose of the presumption is to obviate the need for that difficult weighing up. A weighing up which could be done differently by one creditor or another, and could be done differently by one court or another, leading to uncertainty, lack of foreseeability, precisely the opposite of the concepts that are the whole ethos of the regulation. Where I quibbled slightly with Lord Justice Lewison's formulation is that it may be in a given case that if you have one group of creditors contending for country X and one group of creditors contending for country Y, it may be on a given set of facts nevertheless possible to identify the main centre and to choose between them. And to say that in Lord Justice Snowden's example, there's office in Luxembourg, wherever it is, operations in the US and UK, quite a lot going on in both jurisdictions, but I can nevertheless see that clearly the preponderance is in the US, or the preponderance of the administrative factors, or whatever. On that fact pattern, one would be able to choose between them. But if one couldn't, and if that meant that neither place had emerged as a factor to displace the presumption, then the presumption would operate, and indeed that is the whole point of it.
Yeah, and to spell out one further implication, I mean, in those cases you have two substantial-looking candidates for cases where the main interests of the company are in fact being carried on, but for whatever reason you're unable to choose between them. Having recourse in that situation to the registered office is perfectly reasonable, even if the registered office is just a pure letterbox in a jurisdiction with which the company has no substantial connection in any other respect.
Indeed.
Because it still satisfies the test of providing in a ascertainable public fashion a forum which can be discovered by anyone who's interested.
Indeed, with all respect, I would agree with that. In one sense, that underlies to change the fact pattern slightly and bring it back to our case, and underlines the correctness of Mr. Justice Miles's approach and the unfairness in my own friend's criticism of it.
But of course,
which is that
the Deputy Judge did find it possible to choose between Switzerland and...
He did, my Lord, and as I'll explain briefly, he did on a flawed legal basis, as for reasons we'll see. So it doesn't help my learned friend to say, well, let's have a look at the analysis and let's have a look at his conclusion, because ultimately the premise of that conclusion, if you like, was flawed, and that is precisely the sort of scenario in which Mr. Justice Miles was entitled to interfere. But the judge below, Mr. Justice Miles, was well alive, we say correctly well alive, to the difficulties of assessment in any particular case. And in such a case, precisely in such a case, was alive to the importance of the presumption. So to change the fact pattern slightly from the free country situation where one has registered office, letterbox activity in US and UK, in our case, there was a registered office in Malta, and then there was activity of one kind or another all over the place. There was evidence of directors in South Africa, evidence of directors in Estonia, evidence of legal proceedings in the BVI, evidence of legal proceedings in England, evidence of legal proceedings in Switzerland, arbitration clauses providing for arbitration in London, arbitration clauses providing for arbitration in Geneva.
It's a shame the company didn't actually tell us where its employees were located.
Well, I understand that point.
Told us what languages they speak, but not where they were.
Well, there's only so much more that I can say about that, obviously, in light of the findings that have been made below about it. But ultimately...
I thought the finding below was that you conducted all your business in the ether.
Indeed.
I mean, if you get an email from somebody, you don't know where they are physically. Might not know.
Indeed. And the missing but flawed premise of what my own friend's criticism of this is that there was some hidden bunker underground somewhere, or the employees were hidden or operated. And indeed, the flaw in the Deputy Judge's approach to say, well, I can draw adverse inferences because the company hasn't produced much material. I mean, as a matter of common sense, an adverse inference can be drawn if there's a prima facie case. And if one can conclude that a company not being forthcoming is because there would be some hidden bunker in London or in the Cotswolds or something. But then, in the absence of any basis at all for suggesting, as a matter of common sense, that the missing evidence would have pointed to London, that was a flawed approach, as the judge below rightly held. And so there is only, I accept the criticism to some extent, but there is only so far it can go, because it can't be said that there was, as I say, some great missing bank of information about where employees were, where the office was, and so on. It's just not that kind of company. Before we move off that point, it's maybe a convenient moment to address the scenario that Honourable Justice Snowden postulated before lunch about the particular groups of creditors, where you have finance creditors who extract covenants.
Yes. So this is moving off the question of the way in which the court should approach it with the presumption and the need to have evidence to rebut the presumption. We're now dealing with the question of, is it right to exclude or give low weighting to some evidence because it's not something that a, quote, typical creditor would discover?
Yes, my lord.
Is that the point?
I was going to deal with it. I'm not actually quite yet on that point. I was going to deal with it simply because we were talking about US and UK, and it seemed to fit in there. But I'm happy to deal with it at a later point if it's more convenient.
Yeah, you take your call. Sorry.
I'm very grateful.
I'm just trying to identify the point you're getting to before you make it, so I understand.
Indeed. I think where perhaps I should come back to it in that context, because I'm conscious we've got onto this US-UK point as a coming out of discussion about BVI and so on, but it does fit better, I think, in that context. Just finally on the weight of the presumption, even if the presumption were a weak one, it would only help my learned friend if there were something to rebut it with, something that's actually relevant, applying the relevant tests. So something which is ascertainable in the relevant sense, something which is an indicator of administration as opposed to operation. And as we'll see, that is not something which existed in this case. Can I say something briefly about permanence and stability? this is, in one sense, it's another way of putting the importance of certainty and foreseeability, but the phrase regular basis was discussed this morning, and degree of permanence. Those are both phrases which you find in Mr. Justice Miles's decision and which reflect the authorities. I don't think it's suggested in otherwise. If one looks at the different factors that were relied on by the petitioner in this case, one can see that it didn't begin to meet the requirements of permanence and stability. And I'll come on to look at the factors in a little while. But a useful way of looking at this might be, so if you like, do a time lapse of the relevant chronology and see what one had at any given point in time. At the beginning of the company's existence, it was in 2005, it was incorporated in the BVI. So at that point, before the company had done anything at all, clearly as far as this legislation was concerned, the COMI would be presumed to be in the BVI. One can then zoom forward to 2011, where the relevant set of transactions were entered into, which were abortive, as the Lordships will probably see. And as part of that group of transactions, the company enters into some contracts with English jurisdiction clauses, some contracts with English arbitration clauses, and some contracts with Geneva arbitration clauses. What would one make of that? What would any given creditor make of that?
So the Geneva arbitration clause was...
So that, my lord, is the contract with the company Dartex.
But is that the same time? Was that part of this suite of transactions?
It's part of the suite in this sense. I'll show you the content in a second. What happened was that there was an original set of contracts where Melars, the company, was going to buy oil and sell it on, and EWL, the petitioner, was going to transport it. Yeah. That was generally the position. EWL had sellers that it was going to sell the oil onto, and problems arose because of delays and so on. We don't get into all the detail of it. But in order to resolve those problems, a company called Dartex, which was a Marshall Islands company, came into the picture and proposed to purchase, indeed agreed to purchase, some of the oil that was the subject of the previous aborted transaction. And so in, I think, April 2012, the company entered into this contract with Dartex, which provided for a Geneva arbitration clause.
Although the petitioners are not parties to that contract.
Petitioners are not party to that contract.
It's nothing to do with them as such.
It's nothing to do with them as such, although it's always been the company's case, and this is what the Swiss Criminal Court has now found, that this whole arrangement was part of a fraud carried out on Melars by the controller of both EWL and Integral, which is another company involved in the transaction, and the Dartex company. And so, although it's not technically, wouldn't necessarily have been aware of that contract at the time from its dealings with the company, and that is in fact relevant from the ascertainability perspective. It is a contract that the company entered into, which pointed not to England but to Geneva. So what would one make of that? Slightly later in the transaction in 2012.
It was English law.
It was English law.
English
Yeah.
law.
My own friend points out that it was English law, and that's quite a useful point to dwell on for a second, because to the extent that one can get anything from the designation of a venue, it does at least identify a place where things are going to happen, i.e. a dispute is going to be resolved. What becomes absurd in my submission is to rely on the choice of English law in the abstract as a pointer to a company's COMI, because English law says absolutely nothing about where anything is happening at all. It doesn't tell you anything about where the company is, doesn't tell you anything about where the company is going to be, doesn't tell you anything about where the disputes are going to be resolved, as the arbitration clause in favour of Geneva demonstrates. So that's 2012, and then when the transaction goes wrong, various things happen. There's a flurry of litigation and arbitration, essentially. The company starts proceedings in Switzerland, two sets of proceedings. One is debt collection, it says that it's owed money and wants to get it back. And the other is criminal proceedings, which are the ones which have ultimately been determined, although subject to appeal recently by the Swiss Criminal Court. On the other hand, one has both EWL and Integral commencing arbitration proceedings in England. What happens to the EWL proceedings is that there's a jurisdictional objection which causes the petitioner to let those proceedings lie. They don't go anywhere. Instead, they go to the BVI and they sue the company in the BVI. What happens to the integral arbitration proceedings is that they are pursued. The arbitrator decides that he doesn't have jurisdiction. That's appealed. Mr. Justice Andrew Smith decides that the arbitrator, broadly speaking, was right, so that he didn't have jurisdiction, so dismissed the appeal. There was an attempt to appeal that, which the Court of Appeal dismissed in January 2016, so we're now about 6 months before the beginning of the petition, presentation of the petition, on the basis that they didn't have any jurisdiction to grant permission to appeal. So in all that period, if you like, following the timeline along, you have the company pursuing its own interests in Switzerland, and you have attempts on the other side to pursue the company in England, which are all abortive. The integral ones, because there's no jurisdiction to bring them, so they should never have been brought here at all. And the EWL ones, because, rightly or wrongly, they were aborted in favour of proceedings in the BVI. Now, again, pausing there, could one say, at that point, well, there's discernibly a centre of main interest in England? Plainly not, in my respectful submission. But if one takes it further forward, all of those, everything that happened in England, all the English proceedings are finished by, at the very latest, January 2016, with the dismissal of the appeal by the Court of Appeal. It's common ground that the relevant time for assessing Comey is the
2015, did you say?
January 2016, my lord, was the Court of Appeal decision. The relevant date for assessing Comey is then July 2016, and if one's done a sort of time lapse of all this period, one's had at the very beginning BVI, then some English flavour comes in the transaction. That's then pursued in proceedings. They fade away. They fade away to leave proceedings in the BVI and the company's proceedings in Switzerland. And then by the time of the petition, there is nothing happening at all in England. So when one looks at the need for permanence and stability, it is impossible to see, with respect, how my learned friend's reliance on the factors that were relied on, the petitioner's reliance on those factors, could begin to meet those requirements.
Does permanence and stability, is that in the CJEU decisions? It comes out of the Vargos-Schmidt report. It's not in the regulation itself.
That's right, I think.
Is it picked up by the CJEU?
Well, it's primarily been addressed in these proceedings by reference to English authority. And I think probably fair to say some degree of glossing of the need for certainty and foreseeability and so on. As one looks at what the ECJ has said about the need for foreseeability, my Lord Justice Lewison quoted the Advocate General in Eurofood in the Stanford decision, saying it's important that creditors know the position at the time of their investment. I think it's probably fair to say that the degree of permanence phrasing and the regular basis phrasing come primarily from English interpretations of those principles.
So I'm not sure that's right. The concept of permanence is, as I understand it, comes in much more where there's a Comey shift, when the court is ascertaining whether, in fact, if you like, it's a real Comey shift or whether it's just temporary. And the courts have stressed, if you're going to shift your Comey, it's important to understand that you have moved the administration of your interests on a permanent basis, or at least a foreseeable basis.
Yes.
I'm not sure what stability. I don't think stability comes in anywhere, but doesn't it all go back to the fact that the actual definition of Comey, curiously, doesn't actually refer to main at all. It's not a main anywhere. It just says the central main interest shall be the place where the debtor conducts the administration of its interests on a regular basis, and which is ascertainable by third party. I mean, a lot of it does hinge on the word regular, and that's in the...
Yes, you're absolutely right.
That's
I'm
actually
sorry.
in the
That is absolutely
regulation itself. And the whole point about regular is it's that which allows the court to say, if you like, it's the main focus. In other words, if you happen to have a few contracts and dealings with creditors in a different place or from a different place, that's not what you're really looking for. You're looking for where you do it
indeed
on a regular basis.
On a regular basis, indeed. And I mean, bringing the facts of this case back to that, one can put the point that I'm making a slightly different way. That if one looks at the need for regularity, well, one doesn't get it from anything that I've just explained in relation to that timeline. Certainly, one doesn't get it in any way that points to England.
Yeah.
Yes.
Well, also, I'm going to come on now to the suggestion that Mr. Justice. I should probably do this other way around. The first point, as Lord Justice Lewison has pointed out to my own friend, it is whether Mr. Justice Miles was correct to conclude that the deputy judge had erred in principle. And as to that there really is no real room for serious argument. There were three reasons that the judge gave, and they were all absolutely correct. The first is that the deputy judge, assumed or decided that the presumption had been rebutted without having identified anything to rebut it with. One can see that very clearly from the way his judgment was formulated. It's tab 10 of the core bundle, page 122. So, paragraph 32, he considers there's force in the submission by Mr. Comiskey, who was acting for the company, force in his trading in the ether description, but there were several places from which it administered its interests. It did connect with planet Earth, and he started with a list: BVI, Malta, Estonia, Switzerland, and the UK. Then what he did in 33 is 33 onwards, he embarked essentially on a process of elimination. In 33, he eliminated the BVI, simply because nobody was claiming it. Then in 34, he eliminated Estonia. I don't make any complaint about that. Then in 35, he said that the only thing going for Malta was the registered office. And then he said, in quite an important sentence, the final sentence of the paragraph, it follows that if, and I emphasise that word, if the company conducts the administration of its interests on a regular basis elsewhere, such that it's ascertainable by third parties, that elsewhere can only be either the UK or Switzerland. So what he essentially does in paragraph 35 is eliminates Malta from his list. So he's knocked off the BVI, he's knocked off Estonia, he then knocks off Malta, and that leaves the UK and Switzerland. And he then goes on to weigh up the UK and Switzerland in the paragraphs that follow, if you like, tots up the factors in favour of one or the other, concludes ultimately, much later in the judgment, in 54, which is on page 126, that there's a fair amount going on in both the UK and Switzerland, but by a narrow margin and with misgivings, the UK pips Switzerland. And what he doesn't do anywhere is come back to the question of whether what is going on in UK or Switzerland, whether one pips the other or doesn't, is sufficient to displace the presumption. Yeah. The reason he doesn't come back to do that is because he's already done it. He did it in paragraph 35 when he decided that because the only thing going on in Malta was the registered office, the presumption was somehow displaced as a starting point. Now that was clearly a flawed approach, and Mr. Justice Miles held it was a flawed approach, and my learned friend hasn't addressed that at all, but that is undoubtedly, was undoubtedly on its own a sufficient reason for Mr. Justice Miles to reconduct the exercise afresh. The second point is that the Deputy Judge had relied on Lennox.
Relied on Lennox?
On Lennox, yes.
Yeah.
In paragraph 16 of his judgment on page 118, he cited the Lennox case and said that what Lord Justice Lewison, the attention paid by Lord Mr. Justice Lewison, as he then was, what the Advocate General said about ascertainability is of note. Yeah. He considered it material, and one can see, not just from that, but from the way that he came back to it at 55, page 126. He agreed with Mr. Knight for the petitioner that what was required was not actual ascertainment, although the petitioner creditor had in fact ascertained the comey in the face of a cloud of obscurity. And he noted, as Mr. Justice Lewison, who then was, did in Lennox, that ascertainability is not central, but seems to flow from the fact of where the interests lie. And that is wrong. It explains why the Deputy Judge did not conduct any analysis in the rest of his judgment of the question of ascertainability. He took it to be sufficient that the company had in fact found out various things, and that it had presented those things to the court at the hearing of the petition, and that as long as that was satisfied, whether they were ascertainable in the relevant sense was secondary. And in fact, he just didn't consider it at all, but he said it was secondary, and that was clearly wrong, and a second and freestanding reason why Mr. Justice Miles was entitled to, indeed compelled to, interfere. And the third reason is that nowhere did the Deputy Judge even address, let alone apply, the distinction between operational activity and administrative activity. So Mr. Justice Miles held at paragraph 71 of his judgment that questions like the proper law of your charter party, the seat of the arbitration, the fact that you've engaged lawyers in one jurisdiction or another, are matters going to the company's operations, not to its administration. So, as a starting point, my lords, those three reasons.
You've got to be careful about sort of sticking labels on things and then drawing distinctions between them. I mean, where the company employs a large number of employees to do whatever the company does,
yes,
may be said to be, quote, operational, but it's quite clear that the ECJ and indeed the regulations say that it's important.
Indeed, my Lord. I'm not. I don't seek to put it higher than saying on the facts of this case that the deputy judge failed to consider that distinction.
Okay.
And that on the facts of this case, Mr. Justice Miles was correct to say that the factors relied on actually fell on the wrong side of the line. Of course, I accept that in a case where one could use the much term head office, where there is a head office, and there are staff employed at the head office who plainly carry out administrative activity, and their contracts are governed by a particular law and provide for dispute resolution in a particular jurisdiction. Of course, I accept that in principle may be a relevant factor.
Yeah, I think the point I'm just putting to you is that you may be right to say they are not relevant to the place of administration of its interests for other reasons, because of the proper law of the contract, to take the one you mentioned earlier. But to say the converse, namely that anything which you categorise as going to the operations of its business must necessarily be irrelevant, I think is just substituting one different, equally wrong test for another one.
Indeed. I mean, perhaps a better way for me to put it would be to say that
I mean, let's put it another way. There's no line marked operational and administrative in the regulation on which side you fall rightly or wrongly.
No, that is right. What I would submit is that if a given factor is relied on, then whilst it's not necessarily ruled out by the fact that one could put the label operational on it, one nevertheless needs to consider whether it points to the administration of the company's interests in a particular jurisdiction.
That's right.
And that is what the deputy judge failed.
That's the test.
Yeah, indeed. And that on the facts of this case, that test was not satisfied, because even if in principle matters going to the operation of the business could be relevant, they would only be relevant if they pointed to administration, and they did not in this case. So in my submission, where we are in the flowchart is that Mr. Deputy Judge did err in principle, and Mr. Justice Miles was entitled to interfere. The next question then is, if I'm right about that, whether Mr. Justice Miles went wrong in a similarly fundamental way. There's no complaint for my own friend's submissions on the law. I don't think he actually made any complaint about Mr. Justice Miles' summary of the law. If he was going so far as to say that Mr. Justice Miles should not have applied the test set out by the Court of Appeal in Stanford, that would be a very far-reaching submission and would not be justified by anything that my own friend said. I think actually his submission fell short of that in any event, and was that Mr. Justice Miles had, notwithstanding his reference to that test, failed to apply it. I think the submission is that although he referred to public domain features and features that would be available to a typical third party from dealing with the company, in fact he ignored the latter and focused entirely on publicly available features. That is, to put it at its lowest, an unfair criticism of the way that the judge approached it. Can I take up Mr. Justice Miles' judgment? Core Bundle, tab 5, page 38. This is where he starts dealing with the legal framework. In paragraph 7, he points out the relevant recitals to regulation. One of those, of course, is recital 28, which he quotes in full on that page. A few pages on page 42, paragraph 12, the judge quotes at some length from the Chancellor's judgment in Stanford. And to Mr. Justice Lewison, as he then was, confining factors ascertainable by third parties to matters already in the public domain, and what a typical third party would learn as a result of dealing with the company, excluding those which might be ascertained on inquiry. So far, so good.
The emphasis in that passage, the second part of that passage in any event, is, as we saw, that there is a distinction between that which you might learn, a person might learn in dealing with a company in the ordinary course, and those which you learn by pursuing inquiries.
Indeed.
That's what that was actually, as we saw, was really focusing on.
Yeah, we have to read what I said in the context of the submission that I was
Indeed.
dealing with.
Yes.
No, indeed. Absolutely right.
But what it wasn't intending to do, I think, was to set up this hypothetical typical person that you have to go around yet another person that the English law has invented.
Well,
as opposed to the exclusion, shall we say, of actual creditors.
no, I don't begin to suggest that. And one of the things I say is particularly unfair about the criticism of Mr. Justice Miles's judgment is the suggestion that there were two words that were used repeatedly by my own friend. One, that he introduced this concept of the hypothetical creditor. Nowhere does one see him use that word, or indeed hint at the concept. The second point, and the second phrase that my learned friend used repeatedly, was that he ignored the actual creditor. And again, that is unfair. He didn't, in any sense, ignore what the actual creditor had put forward. He, in an entirely orthodox manner, took the evidence that had been presented by the petitioning creditor and applied the principles mandated by the authorities to that evidence to see whether it passed through the necessary filters so as to be capable of rebutting the presumption.
I think, for example, when you get to it, you'll have to deal with paragraph 87, which admittedly is an additional reason that he gives for not placing any weight on the provisions for choice of law and arbitration. I mean, in paragraph 86, he says, the fact you've got English arbitration, London arbitration provisions is really not very indicative, weighty at all, because lots of people have disputes in London without moving their code.
Yeah.
Understand that. But then he does go on to say it's also that the contracts were with particular creditors, and because therefore they wouldn't be readily ascertained publicly and readily ascertainable by typical third-party creditors, you can't rely on them.
No, and that was entirely borne out by the evidence, which I'm going to come to.
Okay. Because that last paragraph 87 does tend to suggest that you can't rely on anything in an individual contract because the world at large or the hypothetical creditor wouldn't know of it.
Well, one has to read it in context, with respect,
Yeah.
and one has to read it in the context, particularly of the evidence here. And I'm going to go through the operative parts of the judge's judgment, but
I think you need to do that in pretty short order, Mr.
I appreciate that. I am endeavouring to do that. It's paragraph 68. This is the criticism of the deputy judge's judgment, an approach to ascertainability. And then he says, a leitmotif of the European jurisprudence is that only those features of a debtor's administration which are readily identifiable by third parties will be relevant because of legal certainty and foreseeability. And the judge failed to conduct that inquiry. That's the second flaw in his, the deputy judge's judgment. And then in 69, he says there's no reason to suppose that matters such as banking contracts and other things would have been ascertainable to typical creditors. The judge did not address that question separately. He then, in 75, this is when he comes on to his own analysis, talks about relevant factors ascertainable to third parties in the sense explained by the authorities. He's clearly referring there back to the authorities that he set out moments ago in his judgment. That is, again, a correct direction. And he's not talking about, contrary to my learned friend's submission, he's not talking about factors which are in the public domain. What he repeatedly says is factors ascertainable to third parties, and then he says here, particularly in 75, in the sense explained by the authorities. And then when he goes on...
But just
later,
going back to 69, I'm sorry, but perhaps it's just a nitpicking point. I think what the deputy judge said was that they had bank accounts in Switzerland. I don't think he was talking about the terms on which they held the bank accounts, so it wasn't in that sense banking contracts. But if you do business with a company, you might well discover, might you not, where it banks, because either you make
Yes.
a payment into its bank account or you receive a payment from its bank account,
Yes.
and either way you will know where it banks. So the place where the company banks, one would expect, would one not, to be available to creditors, one way or another.
In fairness to the judge, he's summarising here, of course, what the deputy judge had relied on primarily was an English account with a company called Revolut.
Well, the deputy judge does talk about 2 Swiss accounts, which were,
Yes,
which
indeed.
he then
So
says were frozen at some point.
There were 2 Swiss accounts which were frozen, which clearly were ascertainable to the company.
Yeah.
And in fact, one of those accounts was referred to in the contemporaneous correspondence, which was in evidence. So as the Lordship has put to me, and as one would typically see, it says, I'll need your bank details, please. Here they are. Here's my bank account, BNP Paribas, Geneva. That's what happened in this case. There was also reliance on what's called an online money institution called Revolut. And when the judge, Justice Miles, went on to look at that, that's what he's focusing on.
Yeah, well, he said it was too late and it was internet banking, essentially.
Indeed, and particularly that sort of account clearly wouldn't be something that one would expect a typical third-party creditor to be aware of. It's a bit like one can have online accounts for making payment in foreign currencies if one goes on holiday or something, but you don't tell your creditors about that. It's just a sort of internal mechanism for making a payment, very different from a bank account. And so it would be dangerous, in my respectful submission, to assume that in paragraph 69, Mr. Justice Miles is rejecting the proposition that the Swiss bank accounts would be relevant or ascertainable to a third party. And I don't know, I'm going to go through all the different references, but the judge then repeatedly talks about whether something would be ascertainable by a typical third party. And in applying that test, he is applying the correct test. The criticism, there's one criticism, which is that, well, when he did that, all he ended up with was the COMID, the registered office. Sorry, not the COMID, he ended up with the registered office. And therefore, he must have excluded everything else. Well, that's to focus on the result. That was the result. Having applied the test, he concluded that there wasn't anything to displace the presumption. And so you end up just simply with the registered office. But it's not a fair criticism of the process that he conducted, because he did repeatedly have a look at not simply what was in the public domain, but what would have been available to third parties, typical third parties dealing with the company. The question is whether EWL is a typical creditor. In one sense, this is a key point. There, I don't think, is any dispute that the word typical is a correct part of the test. But what my beloved friend says is, we had ascertained certain facts. We put them before the court. There was no other evidence.
Just, what do you mean by typical? That's what I'm trying to push at. By typical, do you mean just not abnormal, not an outlier? Somebody who you deal with once but not regularly? Or by typical, do you mean some notional, every creditor, some notional person fulfilling the characteristics of anybody who would deal with the company? So it's the latter. That's very restrictive. It's
not the latter, it's very much the former, and that is what the judge is doing, because he's looking at the facts of this case and what was typical. I mean, we will need to look at what was typical, and I'm coming on to that. But there is no. This is how my learned friend wants to put his case, and does put his case, is to say that the judge had created this sort of hypothetical, notional, abstract, fictional, whatever that one wants to put on it, creditor, and that he had simply ignored the actual evidence of the actual creditors. But what the judge is actually doing is saying, I can see what this company is doing from the evidence to some extent. I can see how it interacts with its different creditors. And to take the example of paragraph 87, you, the petitioner, say that you contracted under English law with an English arbitration clause. Why would everybody know about that?
Well,
in this case, no reason to suggest that it would. I mean,
well, they may be the only person who's ever dealt with the company.
but in this case, they were not.
How do you know?
Because there was evidence of other people dealing with the company on different terms, and in particular, Dartex.
But okay, so they may be 50% of the company's creditors. Does that mean they're atypical?
Well, one ultimately has to conduct the exercise, which is what the judge
But doesn't the burden lie on the
did.
company to say this person is atypical? This person has a unique experience which is not regular. It's not the way we regularly conduct the administration of our affairs.
I respectfully would dissent from that to this extent, that the legal burden is on the petitioner in a case like this, where it's the petitioner seeking to rebut the presumption.
Yeah.
That much is clear. There could, under English procedure, be a point at which the evidential burden shifts.
Yep.
But you have to get to that point before you can say, well, the company is under some obligation to rebut the evidence that's been put forward. So, for example, if the petitioner says, well, when I contracted with you, you sent me letters from a correspondence address, which was a London address. Why is that not typical? The court might look at that and say, well, you know, why is it not typical? That this is a piece of evidence which, on its own, sets up at least a prima facie case that you would expect an ordinary creditor, a typical creditor, to see. If the company is writing letters from an address in London, why would it not be doing that to everybody? If you, the company, want to say, well, this is unusual. We had some particular reason for writing to you from a London address, but normally we write from a Luxembourg address, then clearly in that sort of case, the evidential burden would shift. Or, to use the example that I postulated earlier, if you have a French incorporated company which contracts on standard terms which have an Italian jurisdiction clause in them, and the creditor can say, well, look, when I dealt with you, you said you've got to use my standard terms. Here they are, they point to Italy. The company could say, why is that not typical? And plainly, in that sort of scenario, the company might be under an evidential burden to displace it and say, well, although you say it's standard terms, actually it's not. Here are 10 other contracts with other parties that are on different terms. We had a particular reason for contracting with you in that way. But a petitioner's evidence might not set up a prima facie case so as to shift the evidential burden. So, for example, in this case, simply for a company to say, well, we contracted on the basis of English law and with arbitration in England, why is that not typical? If the company, as happened in this case, comes back on that and says, well, I take your English arbitration clause and I counter it with a Geneva arbitration clause, what's the position then? Plainly, the petitioner still has the burden of showing that it goes back to the overall legal burden that the presumption has been rebutted. There has to be something, at least a prima facie case, to show that the evidence relied on by the petitioner is typical. But we just didn't have any of that, and that's why one sees in the language of the judge, there's just no reason to think, he says in 87, no reason to think that the choice of law clauses or dispute resolution clauses were publicly and readily ascertainable. I.e., you don't even get to your prima facie case.
I mean, I'll just do it again, but the problem, I think, which is said to exist with this line of reasoning is that the judge has disregarded the weight to be attached to these factors, either because of the nature of the agreement. So, for example, we've had the debate about whether you get anything at all which is relevant to Comey from the fact that there's a contract governed by English law. You say, how could it possibly be relevant to Comey? Understand that submission, and the judge makes that point.
Yeah.
But he also, in relation to each of these paragraphs, 87, 89 and 90, adds the point at the end of each of those pieces of analysis to his primary point, I think, that it really doesn't matter where you specify law or place of arbitration. He adds, in each case, this is a specific contract. I don't see how a, quote, typical third-party creditor could ever been aware of the reference to London in that contract.
Yes.
And that's criticised because that is saying that shuts out as simply irrelevant the actual objective manner in which a creditor, one of only two known to before the court, did actually deal with the company.
Yes, my lord. There are a number of answers potentially to that, or perhaps two principal ones. One, which is very much the fallback point, is that if one actually looks at the structure of the judgment, there are a number of, in each case, independent reasons for rejecting the evidence of a particular factor, which are not really complained about by my learned friend. And so even if he were right in his attack on this typical third-party creditor point, it wouldn't actually go anywhere. But secondly, this is an application of a recognised and correct test to the facts of this case.
But the word typical only really got introduced, I think, or was only really contemplated and considered in the context of eliminating the inquiry type evidence.
Well, if one looks at it in that context, then it's equally apposite, in the sense that these are not factors which would be apparent. There are factors here which will not be apparent except on inquiry. And perhaps we can have a look at some of these factors. If we look briefly at...
I'm going to have to stop you in about 10 minutes' time, Mr. Chair.
Well, I understand that. Yes, I will do what I can in that case. Could we look at the supplemental bundle? Sorry. I'm going to the supplemental bundle at tab 12. This is the witness statement of Mr. Parrish in support of the petition.
Yeah.
So looking at contracts, for example, EWL clearly had its own contract, and so it says it's difficult to locate the centre of the company's main interests, but if the company has a centre of main interest, which one note put particularly tentatively, then we think it's in the UK because over the page, all of a company's known contracts are in English language and governed by English law. B, arbitration clauses, all the company's known contracts contain arbitration clauses providing for a London seat. And then there are footnotes, and there is a reference to the charter party between the company and the petitioner. Well, clearly, that's something which the company was aware of. B, two contracts between Integral and the company, which the company has, but there's no evidence that it became aware of those contracts through any dealings with the company, as opposed to the fact that it's a connected company with Integral, that it's able to identify those through Integral's dealings with the company. Then in C, it says there's a purchase contract between the company and Trafford Euro, which it doesn't have a copy of. And then in D, it says there's a contract between the company and Dartex for the sale of the cargo, and they don't have a copy of that either.
Right. If a company deals with three counterparties, that's all it does, three counterparties. In every case, it specifies English seat for arbitration in the contract.
Yes.
If that factor is relevant at all, which is a different point,
yes.
Assume for a minute it is. The fact that creditor A won't know for certainty and has never seen the contract with creditor B or creditor C, why do you disregard? You'd end up disregarding all that evidence simply because creditor A didn't know what was in creditor B or creditor C's contract and vice versa, when in fact, standing back, you know that every single creditor that deals with the company is required to deal with an English arbitral clause.
In that
if
scenario,
it's relevant.
If it's relevant, of course, and that's a separate point. One would see in that scenario that it's typical. So that it's not because one creditor won't know about someone else's contract. It's because one would see in a scenario where one has a whole suite of English company in every case contracts with English jurisdiction clause. that one can see that is typical. In this case, one has some contracts with English jurisdiction clauses. One has other contracts. If I could just give your Lordship the reference to this, the Geneva contract is at tab 5 of the supplemental bundle, page 53, and that provides for a Geneva arbitration clause on page 55. It's not what the judge is not doing is in the abstract saying simply because one creditor knows about something and another one doesn't, that it somehow is irrelevant. The judge is looking at, and on the facts of this case, the fact that there are very different things going on in relation to different creditors, which make it impossible to say that one creditor or another is typical, or particularly that the petitioning creditor is typical. In relation to litigation and arbitration, of course, EWL was aware of its own claims. How was it aware of the integral arbitration? No evidence that was from dealings with the company. And of course, the arbitration was inherently confidential. Very odd to describe a process of arbitration as in some way ascertainable to any creditor, let alone a typical one, when it's in fact confidential. Why, when there were a whole series of claims in different places, England, BVI, Switzerland, why should it be said that one creditor's proceedings in England are somehow typical? The same point applies to the bank accounts. The only bank account that the company actually became aware of through its dealings were the accounts in Switzerland. The accounts in England, it became aware of through disclosure in the winding up petition. And if one's looking at the perception of the creditor, the particular creditors, the actual creditors, it's very instructive in my submission to look at the way it was put in the winding up petition itself, which is in the core bundle at page 11, just briefly.
Page 11?
Tab 11, I'm sorry.
Tab 11.
In reciting what happens, first of all, page 129, please. The top of the page is talking about the transaction itself. Then it says the amounts due were not paid and the petitioner commenced arbitration in London. Then, your Lordship will be familiar with this, they're not necessarily from this document. It's very similar to the evidence in support of the petition. There's a recitation of how things ended up in the BVI and so on. And then, about halfway down the page, there's a paragraph starting the petitioner's BVI counsel sent several demands. And then the petitioner is informed by its BVI counsel that there are difficulties in winding up in the BVI, essentially. So that's why it's not going in the BVI. Then, over the page, the second full paragraph starting the petitioner, it's explained that the petitioner contacted a law firm in Malta, and their advice was it's difficult to wind up in Malta. And it follows from that it would take months, if not years. Towards the bottom of that page, they say that the sole purpose for which the company exists is to pursue claims in Switzerland. Then over the page on 131, they say, under the heading jurisdiction, second paragraph, it's difficult to locate the COMI. If the company has a centre of main interest, it's in the UK. And so what one gets here is this all feeds into the Deputy Judge's finding at paragraph 22 of his judgment, that the reason they have come to England is because they're forum shopping. There is absolutely nothing to support the proposition that it was actually EWL's perception that the company's COMI was here. And so for my own friend's reliance on the perception of the actual creditor, it doesn't actually take him anywhere at all. I was going to address at this point the two groups of creditors point, if I may briefly, that Lord Justice Snowden postulated. The answer in that scenario, in my submission, is fundamentally, as it always is, one has to apply the test. In some cases, if there are financing creditors with covenants, Comey covenants, one could call them, in favour of England, that would be determinative. Maybe that there's no other evidence. Maybe that if there were no other people appearing on the petition, then as between those parties is actually a contractual estoppel to that effect. It may cement an existing position if there's already evidence of activities in this jurisdiction. But in answer to my Lord's question, why are the finance creditors not entitled to rely on that they would be up to a point. But similarly, if the only thing going for Comey in England was a covenant to that effect, and one could see that the real situation on the ground was that everything happened in France or Belgium, equally, why could the trade creditors who deal with a company in those places not be able to say, well, as far as we're concerned, our perception is that the real Comey is in one or either of those places?
That's just a question of weight.
Yes, ultimately, the court would have to do the analysis, and it may come back to this US-UK example we talked about earlier, where it is actually just not possible to find a single place, in which case one falls back on the presumption. Or it may be that in the facts of a given case, the Comey covenants carry the day, and it may be in another case that they don't. It's a collective proceeding, so fundamentally the court has to take that into account, not just what particular creditors think, but what the typical creditor thinks. Just to wrap up, if I may, my lords, I'm not going to go through these in detail, as my learned friend didn't really touch on them. There was a whole host of other factors that Mr. Justice Miles relied on, as I think my lord has indicated, in relation to these different factors, to point to why they were not relevant. So, English law is not a connecting factor. It's completely unremarkable, as is an arbitration clause, and so on. And quite apart from the criticisms, and even if those criticisms were justified as to the typical third-party creditor points, those are all freestanding reasons why the judge was entitled to reach the decision that he did. May I just turn my back on my lords for one second? The only other point, my lords, is that I'm not sure that we end up actually getting. We say we don't get near this. That we have a respondent's notice to the effect that if the judge was wrong to conclude that the presumption hadn't been rebutted, the only credible alternative candidate was in fact Switzerland. Switzerland, where it had its bank accounts. Switzerland, which was the only place where it was pursuing its own activities, where it was suing the debt collection proceedings and the criminal proceedings. But in my submission, we don't get anywhere near that on our primary case. Unless there can be a further assistance, well, those are my submission.
No, thank you, Mr. Sheehan. Mr. Levy, do you want a few minutes in reply?
My lord, I don't think I'm going to reply in any great detail.
I wouldn't let you.
Sorry?
I wouldn't let you.
That's why I said it. My lords, you have our submissions. The new authority, I don't think, really adds anything to the debate. I would urge the court on the question of weight. I think footnote 2 in our written submissions, which is towards the end of the core bundle, refers to a number of textbooks, some of which do suggest that the presumption isn't particularly weighty. We would urge the court, if the court's minded to reserve, to just have a look at footnote 2 to our submissions. My lord, so far as the respondent's notice is concerned, that would bring into play the late reefers jurisdiction to wind up companies, and that should go somewhere else. But I'm not sure you want to hear me about that.
I'm hesitant to interrupt. We wouldn't do, because there was an attempt to bring that in and it was dismissed.
Well, if the late reefers jurisdiction exists, then it would be odd if simply as a matter of procedure, the court, because we weren't given permission to raise a point, would nonetheless find that the co-news was in Switzerland without addressing that issue, put it that way. But my Lord, I think it's probably late enough, and unless there's anything I can specifically assist the court with,
No, thank you
I'm
very
very
much.
grateful.
Well, thank you both for your arguments. We will, as Mr. Levy has anticipated, reserve our judgments. You will get draft judgments in the usual way. It's your chance to correct our English but not our reasoning. The draft judgment now comes with a beefed up embargo, which means what it says. If we would hope that in the light of the draft judgments you will be able to agree a formal order disposing of the appeal. But if the form of order can't be agreed, then please make short written submissions and we will make the order that we think is appropriate.
Right.
Thank you both very much.